Welcome everybody to what is now episode 10 of our video series on tax talks. Alex, welcome again. This time we've got a double tax agreement scenario. So this is a story of a taxpayer who is, correct me if I'm wrong, Alex, but both a Singaporean and Australian resident for tax purposes.
Correct.
And we had to work out essentially who gets to tax what. So a double tax agreement, for those of you who don't know, is a bilateral agreement between Australia and another country. And at the moment, I think we have something like 41 or 42 countries with whom Australia has a double tax agreement. Singapore is one of those countries. And this is kind of, I guess, relevant, Alex, because we've got a lot of people who do live across borders now and have dual residency or citizenship. So briefly, lay out the facts of the case for us, Alex.
Okay, so when you look at this particular case, involved a taxpayer called Mr. Bulie, B-U-L-I-E, and he went and worked in Singapore in a fairly high-paying job. He had an accommodation over there, job, and economic connections. But he also had his wife and his young child back here in Australia, and also they lived in a home that he owned in Australia, in Sydney.
Yes.
So the issue was back in 2018 to 2022, he always argued that he was a non-resident because he said, look, from a non-resident, I can only be taxed on what I earn in Australia, but I didn't earn anything because my source of income is my employment in Singapore. Therefore, as a non-resident, I don't have tax in Australia. And he argued that he was a Singaporean tax resident. So under their rules, if you're in Singapore continuously for at least 183 days in the year, then you're a tax resident. So he said, tax resident, I want a favourable Singaporean tax rates. But this tax office said, no, you're an Australian resident. We want to tax on your worldwide income. So the amount that he actually earned in Singapore, why this was critical, was $700,000. So if you imagine that tax in Australia, it's a significant amount of tax. And that's why this case really came about. So an argument, taxpayer, I'm a Singaporean resident. There's an argument by the Australian tax office that he's an Australian resident. So we've got this issue, which country is he a resident of? And that, Venkat, we have to look at the double tax agreement between Australia and Singapore.
Yep. And the double tax agreement is I guess, they were brought into place so that when situations like this do arise, that there's some kind of framework. Now, we've got to also remember the double tax agreement is basically just a very vague framework.
Correct, yes.
It doesn't sort of say you do exactly this, exactly that. So it's not like it's going to help you straight away, but it gives you some framework.
Correct. And one of the practical problems you'll find with this case is twofold. One is that when you look at it, he was arguing, well, the tax office was arguing about the year ended 2018, 2022. It wasn't decided until 2026. So he had to go through this crap for 4 years. Talking, dealing, negotiating, getting stressed out with the ATO. So when you look at it as a practical person saying, well, how do I avoid this problem? And with this problem, you've got to say, okay, look at the facts of the case of Mr. Bulie. Because it's very much factual. That's how the tribunal came to its conclusion, is to say, well, what should I be doing to avoid having this argument with the ATO in the first place? And that's really, and as you said before, Venkat, there are a lot of people that live in Australia that decide either because they have to or are asked to go and work overseas. So they become tax. And there are a lot more of them over there. And this is a key issue for them to avoid Australian tax resident when the majority or all of their actual income is from overseas. And that's why this case becomes important from that point of view.
100%. And also, I think we'll talk maybe a little bit about this towards the end, but, you know, how do you avoid getting into the situation this taxpayer's got into? And I think there's some things that you can do which would make the case a lot more clear-cut. And so we might come back to that towards the end. But essentially with the DTA, what the DTA does in circumstances like this is in this case, it was the Administrative Review Tribunal, wasn't it, that this case was in front of? It didn't go to the courts, or, well, the ATO might appeal the decision, it might go to the courts. But they had to basically look at, when it comes to the tiebreaker provisions, you get to the point where I go, where is the person's closest economic and social ties?
Correct.
And the reason why it was kind of quite split here is because his wife and child, I think wife and one child,
Correct.
were here in their family home, which he owned jointly with her, with the wife.
Yes.
And so clearly, he's got very strong connections back to Australia.
Correct.
And correct me if I'm wrong, Alex, but I think
He also had his private health insurance. So he had a lot of things.
that's right.
Practical. I mean, you could argue, well, they tie you to Australia, your wife, your child, your health insurance, your life insurance, and the fact that, you've got a home in Australia. All right.
Well, and the income he was earning over there was being used to support his family here as well. So it's not like that was independent either. So that's another complicating factor here. Now, I must admit, I was a little surprised that I think that the ART found that his closest economic... Well, they said they placed more weight, I think, on the fact that his economic ties were primarily Singaporean, which is, of course,
Correct.
factually correct.
Correct.
He had no income from Australia. His only income was really the salary from Singapore.
Correct.
So they're certainly spot on in saying that the bulk of his economic ties
Yes.
are in Singapore. But I wonder whether the ATO will appeal this and say, well, what about all the rest of his connections to Australia?
And I think what this case also points is when you look at this concept of residency, as we've told students in our classes, is it's factual. And factual means each of us will have a difference of opinion, which this case demonstrates. The ATO has one view, the client, the taxpayer, has the other, Mr. Bulie. And at the end of the day, the person in the middle, the judge or the Administrative Appeal Tribunal or ARTA, is listening to both sides, says, I like your argument, I like your justification, or I like your argument, I like your justification.
That's it.
That's why it's important when you come to a discussion or interpretation of factual things, you have a basis on which to argue your case. Because if you don't have a basis, you're never going to get past first base. And that's critical both from a client point of view, the real people, Mr. Bulie, and also for the advisors to understand they have to justify their opinion.
Exactly.
Now, make the decision based on the basis of your arguments.
Yes. And so, in a way, that provides some comfort to the public because the facts should at least eventually overrule any kind of sort of subjectivity or bias that one party or the other may have. Now, let's talk a little bit about what we might do if you're in a situation like this. Now, if we just take this particular case, the Bulie case, and if we have a look at what he could have done to make this tiebreaker provisions very clearly fall in one direction. And I think at the end of the day, if we were advising someone, right, you'd want to give them advice that gives you 80%, 90% chance that the dice will fall in a particular direction.
Correct, yeah.
So here, if we looked at this case, I reckon, and you tell me what you think, Alex, if he had leased out his house in Australia, if he had moved over there with his child and wife,
yes, wouldn't
this have been a much more clear-cut case?
It would be, because when you look at the tiebreaker provisions, there's three, and you go through 1, 2, 3. And the first one is, which country do you have a permanent home? Now, argue that because his wife and his child were living in the house in Sydney that he owned with his wife, that's his permanent home.
Yep.
For whatever reason, ARTA said, no, he's also got a permanent home in Singapore because he's living in rental accommodation. But the concept of permanent, you have to go back to Applegate's case, etc. Permanent doesn't mean, but it's your connections, if you like, to the country, and the type of accommodation you stay gives an indication of permanency. Now, the fact you might have a long-term lease in Singapore would argue it's permanent. So therefore, they said you got permanent in 2 countries. We have to go to step 2, and say which country is your normal habitual abode. Now, if you look at the numbers between 2018 and 2022, 38% of this time was spent in Australia.
Correct.
It therefore was in Singapore. So you could argue, well, habitual abode is therefore technically in Singapore.
Yeah.
That's a matter of it. But they said, well, because you spend time here and you spend time there, you got habitual abode in both countries. Because then again, they looked to the wife and the child, basically. So they looked at the third and final test or tiebreaker provision. They said, okay, which country do you have your closest economic and personal relations? So it's not personal or economic, it's the combination of the two. And
yes.
As ARTA said, we're going to put more weight on the economic.
Yes.
Look at all the facts. Yes, personal, you've got your wife, your son or your child in Australia, but economically it's in Singapore. That's the bulk, as you said, Venkat. He's earning in the information $700,000 as for a derivative oil company.
Mm.
So he's making a lot of money, and he's obviously using it to look after his family in Australia.
Yep.
So also we favour the economy because everything is driven from there. He doesn't earn the money. How can he support his wife, family, etc.? So the court favoured the concept of economic over personal.
Correct.
Personal, and so this demonstrates that you have to look at both and see in practice which one is more critical or outweighs the other.
Exactly.
That's how they came to the and said, guess what? You're a Singaporean tax resident, which means you're a non-resident of Australia.
Yes, in terms of that income. But like I said, I think if we had taken his wife and child over there,
Correct.
leased out his property in Australia,
Correct. Yes.
he would have got both the economic and the personal connections being very clearly close to Singapore than to Australia. So I think if people are just a little bit more careful about making sure that when it comes to the facts, make it as easy for yourself as possible.
Correct.
Now, of course, it's not always possible that you can take your partner or wife or husband or child with you, but it does create more complications.
I think it's easy to say that, but you can look at the individual circumstances. If you've got a young child and spouse, if the child is just starting school with his health issues, whatever, yes, it makes logical sense.
That's right.
Australia. If they don't have that issue, then the question is, why haven't they come with you? If they're at uni, so they're no longer 18 or at high school, and they started a course, okay, then yes, it makes sense for them to stay in Australia. So, it's easy to say yes, go on, but there will be soon where you can say, I can justify them staying in Australia for other reasons. So that wouldn't say that means it's a permanent home. So there are personal reasons why I think in this case it existed.
Okay.
And, because not everybody likes the heat sometimes, all right?
Yes.
Or like spicy food, whatever it may be. Okay. So there will be reasons. And this, again, I think Venkat demonstrates that when you look at the concept of residency, it's very much based on the facts. Because what if he had the $700,000 in Singapore? What if he had $20,000 of investment income?
Yes.
Would that make a difference? And it's all these little things.
Yes. Understand
and argue, yes, it does, no, it doesn't. So look at percentages, for instance, whatever. So, don't take, I think, as a practical point of view, if you're going overseas to become an expat, don't rely on what happened in Bulie's case, because your circumstances as a person going overseas
yes.
will be different to him. And
yes.
get advice, say, what do I do to break as much and as practically as possible my connections to Australia and create more and more with the country overseas?
Yes. Well, assuming the other country has a lower tax rate than us as well. So, yeah, all right. Well, that's a nice little case there, I think, Alex. And it also shows that things like residency, still remain an open issue as well, despite so many years of cases and legislation and attempts to try and simplify it.
And I think it's more an issue because, people do move. We're a global economy. We move. We don't always stay in Australia. So companies overseas come and work or set up in Australia. Australian companies set up and work overseas, etc. And work for international companies. So the issues in this case are relevant for a lot of people that are working now.
Yes.
Overseas. Now, then the issue becomes, when you go overseas, is it a secondment, is it a transfer, or whatever it may be? And those terms have different tax connotations.
Well, how about we finish off on a controversial note, Alex? How about we all just have the same tax rate across the whole world and that'll fix all our problems? We don't have to have DTAs then.
Well, I think it doesn't matter if we do have a zero tax rate worldwide.
I don't think a zero would work for me, Alex, for anybody. But
because then it forces the government says, okay, if you're smart as the government say, okay, if I can't tax the income, let's tax something else. Okay, which we do, because if you think about it, we tax GST, we tax anything, we tax carbon emissions and so forth. So really, if you don't tax personal exertion and income, we can tax other things. And,
that's true.
Drive towards consumption as the tax. And I think, my theory is the more you have, Venkat, the more I have, the more I'll consume. And
that's generally the case.
And therefore, I'll pay when I consume. So pay as you go or pay as you need.
Yes, no, I certainly think that's the view that a lot of people are taking now. That it's much more, and actually, when you think about consumption tax, it's also the easiest way to tax higher income people, because as you said, they're the ones who are actually going to have potentially much more spending than people on lower incomes. But anyway,
have the capacity to buy more expensive luxury goods. Fine,
Precisely.
pay the tax. People that can afford, as a percentage, it's still 10%, but it's a lower percentage overall of the cost.
Precisely. Yeah. No, totally. Well, that was an interesting case, Alex, and I think we'll leave it here. And in the next one, I think we're going to talk about, again, foreign residents, but CGT next time.
Correct, particularly with the changes that were announced on the 12th of May. Yeah,
which people can look at our previous videos on the changes to CGT that we've done a little while back. Thanks, Alex. See you next time.
Fine. Take care. Bye.